Hello, everyone, and welcome to today's live session from FaceUp. Today, we're talking about navigating the whistleblowing landscape in the UAE. I have a really great guest today that's going to give us some insights into legal regulations and changes and updates that have happened recently. Sabrina, if you mind, could you just give us a quick introduction to yourself and your company?
Yeah, sure. Hi, Ry. It's good to be here. My name is Sabrina Saxena, and I'm a senior counsel in Tamimi, which is a law firm across the Middle East.
Just to be mindful of the time, Sabrina, if you don't mind, I'm just going to dive straight into one of our first questions. The first question I'd like to dive into is, kind of naturally, what are the key regulatory developments in the UAE, specifically for whistleblowing or whistleblowing protections or regulations?
As a first point or a preliminary point, in general, it's important that everyone is aware that each industry has its own specific requirements, which could either, promote or hinder growth. From a legal perspective, it's important to understand both sector trends and challenges, as well as looking at, complexities facing companies which are operating in the Middle East, and being able to understand and navigate those, legal requirements, looking at from both a commercial perspective and a geopolitical perspective, is probably key to determining what type of whistleblowing policy or procedures are best suited for your particular company. And I think, just generally looking at speak out culture, it is rapidly evolving now in the Middle East, especially given, a number of nuances in the legislation, which, Ry, you and I are going to discuss later on in the seminar. But essentially, as everyone knows, a whistleblowing system enables confidential, standardized, reporting of irregularities or concerns. So as an employer, it is good practice to create an open, a transparent and safe working environment where employees, feel able to raise concerns without fear of retribution or retaliation, which is a key issue across the world, let alone in the UAE. Now, although the law doesn't specifically require in the UAE for employers to have a whistleblowing procedure in place, obviously the existence of one would demonstrate that the employer has a commitment to listen to and act upon the concerns of its employees. As I mentioned very briefly before, there is a very important consideration in the UAE specifically around confidentiality and confidentiality obligations that both employers and employees have for each other, which could potentially result in disclosures being made anonymously and securely to mitigate risk of retaliation. And there are mechanisms now that are becoming more and more popular in the Middle East, especially given, maybe the worldwide development of whistleblowing generally, and the evolving landscape in the Middle East, which is, a great reason to partner up with FaceUp.
Some situations require, if we're focusing just on confidentiality or if we're focusing on privacy, we're focusing on anonymity, all of which have its place. And in some countries and in some places in the world, that's legally required. Some of it is, some parts are required, and some of it is really just strictly up to, that organization. The thing with FaceUp is we try to cover all of those bases.
It's a great time for FaceUp to be in the Middle East now, especially given the evolving landscape here, the implementation of a number of new laws, and there are a number of nuances in the Middle East that, aren't necessarily there in legislation around the world. So, it is important to get legal advice and support when conducting these type of procedures. I think as a primary point, there are essentially three different jurisdictions in the UAE. There is the DIFC, which is the financial center in Dubai, the ADGM, which is the equivalent financial center in Abu Dhabi, and then the UAE as a whole, excluding those two jurisdictions. And there are different laws and regulations in each of those three jurisdictions, which I will try and explain in brief. As I mentioned before, the legal framework on whistleblowing and the protection of whistleblowers is still a developing area in the UAE. And at present, there is no express provision in UAE law that defines whistleblowing, except for in the ADGM, which I will again come on to because that is quite a new recent development. But essentially, whistleblowing is a disclosure of often confidential information that is usually made by an employee or an ex-employee of an organization, sometimes exposing illegal or unethical practices within that organization. Now, in the UAE, except for in the DIFC and the ADGM, there is no overarching law that really governs whistleblowing or deals with the protection of whistleblowers. But there are some, I guess, federal and emirate specific legal mechanisms that can be construed as perhaps offering some level of protection, which can extend then to whistleblowing. So I wanted to take you through a couple of the main provisions that I think are applicable in these type of cases. And the first one is the UAE Penal Code. Now, anyone from the UAE will know broadly what the Penal Code is. But on a federal level, the Penal Code provides essentially for a positive obligation for all individuals to report criminal conduct, whether that's an individual or an entity. But in practice, in an employer-employee relationship, it's quite rare for an employee to make a protected disclosure about his employer to the authorities. Now, the reason for that is because all employees are under a statutory obligation under the Penal Code to maintain the confidentiality of their employment. So, in the event, let's say, a whistleblower discloses confidential information about their employer to any regulatory authority or even to the UAE police, not only could he be in breach of his employment contract, but he could also be in breach of the Penal Code. So that's a very specific UAE nuance that possibly isn't there in other jurisdictions around the world. But consequently, the employer could essentially take action against the whistleblower personally, potentially resulting in police investigations and criminal proceedings for breaching their obligations of confidentiality to their employer by reporting misconduct.
That's a pretty tricky part right there.
It is a very tricky part. How do you balance making a disclosure versus your own obligations under the Penal Code to confidentiality?
Even if you might have, let's say, like some kind of agreement, NDA, or any of these types of things with your employer, there are other types of, let's say, like legal protections that say, like, if you're disclosing anywhere, internally or externally, it's set up in a slightly different way. So what you've just mentioned almost it opened my eyes, like, oh, it's not as easy, and you really have to, you as an individual have to know the steps you're taking before you maybe doing the right thing, but you might find yourself in harm's way, right?
Exactly, yes. As an individual, I think it's really important for you to be aware of, not only your obligations, but also your rights in terms of what is best for you. Should you be making that disclosure? Under what channels? How would you, maintain your own compliance with the laws in the region, but also, bring to the attention of the authorities a disclosure that you feel needs to be made in good faith. And that is a very, in some cases, tricky balance for individuals to meet in terms of their obligations, both to their employer and in the UAE generally. One of the laws that I actually wanted to raise was the labour law. So if we exclude the DIFC and the ADGM currently, the remainder of the UAE is governed by the UAE labour law. Now, this is a new law that came in only, very recently, a couple of years ago. But the new law includes a provision around unlawful termination, which could potentially be construed as providing some level of protection for whistleblowers. But essentially, the law provides that the termination of an employee's employment by the employer could be considered illegal if the termination of the employee was due to the employee filing a serious complaint or a claim against their employer that has proven to be true. And if that is the case and the court deems the employment termination to be unlawful, the court can award compensation for up to 3 months' salary. Now, it's not a direct protection because it doesn't protect the individual from their employment being actively terminated, but they are eligible for compensation in those types of circumstances.
Yeah, okay, that's clear. Okay.
And then separately to that, there's actually another law called the Dubai Financial Crimes Law. So back in 2016, the Dubai government implemented the Financial Crimes Law, which offers some protection to a reporter against both discrimination and mistreatment in the workplace, to not be considered in breach of any obligations or kind of subject to any legal or disciplinary action unless the report is false. There hasn't been too many disclosures that are being made under the financial crimes law to date, but given that there are, developments, I guess, over the whistleblowing landscape in the recent years, we would expect that to, start picking up and increasing over time.
Yeah, and with that increase, I think, well, again, that's another part of the reason why we're having our session is to help both organizations and individuals know that there are legal experts that can help you navigate this, as a little nod to the title, but also on the FaceUp side, our software and our platform is really meant to cater to these very diverse situations. Again, just kind of being mindful of the time. I'm already learning so much right now, and I absolutely don't mean to rush you, but maybe if we could maybe jump ahead a little bit, if you're okay with moving into the DIFC, and then we'll get to the next one, because I still have so many questions for you.
No, absolutely fine. Look, in the DIFC, it's slightly contrasting to the UAE, and the DIFC has implemented DIFC operating law, which governs whistleblowing protection in the DIFC. And that applies to any employee or anyone working or operating or conducting business in the DIFC. Now, under that law, a person who makes disclosure to either the DIFC Registrar of Companies or the DIFC entity's auditors, or even to a director or an officer of that DIFC entity itself, is entitled to protection. So it does contrast quite significantly to the rest of the UAE. Now, the disclosure itself has a number of requirements, including, the requirement to identify the person making the disclosure. There must be a reasonable suspicion that their entity itself is in contravention of the law, and it must be made in good faith. And so where a report is made in good faith, the operating law provides that individual should not be subject to any legal or contractual liability. They shouldn't be subject to any adverse consequences or dismissed from their employment or otherwise subject to any kind of detriment, I guess, by an employer. And any breach of the law in that respect could result in fines being imposed against the employer. So there is some form of an active detriment of retaliation or retribution in those types of circumstances. Now, separately to that, the DFSA, which is the regulatory body of the DIFC, has also launched its own regulatory regime that applies to DFSA regulated entities, so entities like law firms, banks, financial institutions. And that regime provides for enhanced legal protection for individuals who report misconduct either internally within the DFSA itself and the DFSA regulated entity, or to their auditor, the DFSA, or a law enforcement agency. Now, that regime requires all DFSA regulated entities to put in place measures to protect the identity of the whistleblower and to protect them from suffering any detriment. So again, this goes back to kind of the confidentiality angle that we spoke about at the beginning of this seminar, and how it's best to ensure that there isn't this kind of risk of defamation, risk of breach of confidentiality obligations. And the DFSA really does capture that in their regime.
Yeah, and since we kind of already touched on it, why don't we just jump straight into the ADGM? It's actually one of the bigger things that I know we were meant to talk about today, not only because I think it's, again, quite recent. All of these are recent, but this is one of the bigger ones that has both appeared in the news and the research that I'm kind of doing. So I'm very curious to hear a little bit more.
It is very recent. It's actually the most recent update we've had from a whistleblowing perspective in the UAE. So at the end of 2022, the ADGM published its own whistleblowing guidelines for ADGM entities, so only those entities that are established within the ADGM, which are essentially intended to ensure that whistleblowers are given adequate opportunities to speak up and are fairly treated when doing so, which is obviously, somewhat of a contrasting position, having a look at the federal laws in the UAE in other jurisdictions.
Yeah.
I mean, whistleblowing under those ADGM principles is broadly defined as the reporting of suspected wrongdoing to someone in authority. Mm-hmm. And a whistleblower is defined as the person who makes the report, whether that person is part of the organizations, whether they're an employee, or they could be an external third party. So the ADGM principles actually do make that distinction between an employee or someone who is not an employee, who is not employed by the company, but is an external third party. So that's quite separate to, I guess, the regulations and the laws in other jurisdictions. Now, under the ADGM principles, where disclosures are being made, ADGM entities are required to appropriately have independent, skilled professionals that are involved in assessing and managing whistleblowing reports. Again, it shows a level of, I guess, transparency, fairness, and objectivity to looking at and investigating whistleblowing complaints or protected disclosures made.
Yeah.
Now, there are both internal channels for raising protected disclosures, and there are external channels as well. So internal channels, the principles provide that any internal channels for raising issues around protected disclosures should be provided to ADGM entities and communicated clearly to staff, and where applicable, third parties, for example, external contractors, suppliers, distributors. And external channels for whistleblowing should also be identified and clearly communicated to staff. So whether that is an internal policy where you have, let's say, a whistleblowing committee, and you're able to, make a protected disclosure to that whistleblowing committee, for example, or whether the entity itself has an external channel, whether that's to another group entity, to a regulator, to the authorities, or whatever the case is. But in either case, they should be appropriately communicated and documented. Now, one interesting thing is that there are no express mechanisms for protection for whistleblowers that have been set out in those principles yet, but they do confirm that protection should be afforded to anyone who, again, reports in good faith, and that confidentiality should also be preserved.
Yeah.
And then the only last thing that I really wanted to mention that's important for everybody to know today is that there is an obligation for any ADGM entity to ensure that they comply with those principles as of the 31st of May, 2025.
Okay. And that's, well, it's not tomorrow, but it's definitely coming up soon.
It's coming up.
Especially when we're talking about like maybe larger enterprise or business organizations. I think we all know that you can't just snap your finger and things happen. There's legal process, as you're well aware of, but also it takes time.
There are often, a number of management approvals that need to be required. There is, internal discussion around whether another policy could be adapted for use in the ADGM, whether global, guidelines that perhaps, a multinational company has is suitable for use in this case. Do you need to start from scratch? What are you looking for in terms of your policy? How are protected disclosures going to be communicated? I mean, these are things that do require some thought and do require, and often in a lot of cases, approvals from different stakeholders in the business. So you're quite right when you say there is a sense of urgency.
What we just covered are kind of like the more technical, let's say, like hurdles or the legal hurdles to actually implement this before a deadline. But in addition to that, there's also, education and training that has to go into it. If you're the the internal legal authority for them, you have to be able to know how to manage it. You have to understand your compliance obligations. So it's not just about decide on a policy, whether a legal expert like yourself or your company provides a framework, or even like FaceUp, for example, we do provide a template, for creating a whistleblowing policy or these other types of things. But even with those tools and even with that support, it still requires a little bit of time. We're all human, right?
Yeah.
We have to learn it, use it, be familiar with it, so it's not, I think it's not only about a deadline to say we're legally compliant or what it may be, but it's also about how do we use it? How do we understand it? And can we transfer that knowledge in a way that is effective, right?
Yeah, absolutely. It's about implementation as well, isn't it? So training around it, as you said, ensuring that you have the correct policy and procedures in place, but ensuring also that your workforce is aware of it, that they understand it, that, any questions that they may have been raised, that they had been training sessions on it.
Yeah.
And that process does inevitably take time.
Again, from your perspective and also your knowledge, what are some of the best practices for conducting internal investigations, but also how do you, kind of balance, you talked a little bit before about confidentiality and defamation and these things. So how do we balance all of this? What are some best practices? How do we do internal investigation? These are all complicated terms if we're hearing it for the first time, right?
Well, yeah, absolutely. I mean, look, I think, investigations are extremely important part of, the employee relationship and business operations as a whole with the company. And across the three jurisdictions I mentioned before, so you've got the UAE, DIFC, and ADGM, in all three jurisdictions, we would always strongly recommend that an investigation is being carried out before, any form of a disciplinary sanction, whether that's, a notice or termination, is imposed. Now, my strong recommendation is any investigation that is carried out in writing. The labor law specifically requires or has, a statutory minimum process that needs to be followed from an investigatory perspective. The DIFC and the ADGM do not, but ultimately the same process should broadly be followed in all jurisdictions. Ultimately, it would be, notify the individual that an allegation has been raised, again, in writing, invite that individual to a meeting, discuss it with them, hear their comments, hear their explanations, hear their representations. And once you've heard that, you can then go ahead as a company and conduct your investigation, whether that's holding a further meeting with them, with witnesses, with another individual, having a look through email correspondence, IT support, for example, depending on obviously what the allegations are and what kind of route that investigation goes down. And obviously, once your investigation is then concluded, have a written outcome of that investigation, explain the conclusion that you've reached and how you've got there, notify then the individual whether a disciplinary sanction is being imposed, and if so, what. And that copy is then kept on the employee's personnel file. I've mentioned, I think, repeatedly now that it should be documented in writing. I mean, ultimately, where the investigation is not documented in writing and the individual states that, for example, their employment was terminated due to misconduct arising, and concluding as a result of that investigation, and they turn around and say, no, it wasn't for that. It was for, discrimination, for example. The company is then somewhat on the back foot in defending any claim of discrimination that's been filed if that investigation isn't documented in writing. When you have a documented investigation process, that of course supports the company's position in terms of what has been done, why have you reached the conclusion you have, and what was the reason for the termination or the sanction being imposed. Now, it obviously makes, from an employer perspective, life much easier, but also it goes to show that the employer is a conscientious employer. It is conducting a thorough investigation into allegations that have been raised. It's not dismissing them. It's not waving them off into the background. And it is concerned about allegations that have been raised by employees, whether that's, health and safety concerns, well-being concerns, is the workplace a safe environment for its employees? And you're really now showing that you as an employer are a conscientious and supportive employer to your employees.
If I can just jump in there for a second,
Yeah.
That's a really important thing that I'm seeing now with all of the guest speakers that I've discussed, and again with the research and writing that I'm focusing on. It's a big thing, I think, for employees to feel that they're working for a company that shares or holds those principles. And it's not, we can talk about well-being and we can talk about, perks and benefits and all of these things that I think an employee wants, but to know that you're considered and cared for in this regard, and they take concerns seriously, and they give you an opportunity to voice that without some of the phrases that you used before, which are, very familiar to me, but without the fear of retaliation or types of things. I think that's another shift in what employees expect of their employer, but also what employers genuinely want to do and show that we are good. It's a good place to work because of these things. We do care.
Yeah.
We take it seriously. And I think that's also becoming, I dare say, not even a trend. It's almost becoming like somewhat of a standard in definitely in certain places. And maybe that's now becoming a newer trend or standard, in the UAE as well.
Yeah, no, I would totally agree. And I think, linking back these type of investigations and what we're talking about being a conscientious employer to whistleblowing, again, and we obviously mentioned the ability for an individual to raise a complaint anonymously. And of course, it is permitted in the UAE for complaints to be made anonymously. And an employer could adopt a policy which seeks to preserve the identity of somebody making that protected disclosure. But on the flip side, anonymous complaints can be attributed to a lower status, given that they are anonymous. And it can then be quite difficult, if not in some cases, impossible, for employers to take action lawfully against, say, alleged perpetrator, if the only evidence available to the employer is an anonymous complaint. I mean, obviously, the expectation would be that the employer would investigate the complaint made, seek to obtain additional evidence which could either prove or disprove the allegation. But often you see complaints being raised anonymously, and then the employer is in a position where they are unable to ask any follow-up questions that they might have had. So, there are, I guess, two angles to look at it here. Making an anonymous disclosure obviously protects the person making the disclosure. On the flip side, it may then limit the ability of the employer to, I guess, investigate that disclosure to an extent that it feels comfortable with, and has the ability to conclude or have an outcome of that investigation. So I think for employers, especially in the UAE, given both of those angles, having a kind of policy in place, ensuring or giving employees security of being able to make disclosures confidentially, that even if they do make them and disclose their name, disclose their details, but know that there is no risk of retaliation, there is no risk of anyone finding out that they made this disclosure, I think it's really important in a workplace context.
The important part, if I can, again, just mention a little bit about FaceUp, the important thing that we focus on there, again, is to cover both of those bases. Because if someone does report anonymously, our software, our platform allows, it allows two-way communication without disclosing more information than you're comfortable with, like, your identity and personal information. So it takes a step in that direction to say, like, we don't want it discredited. We still want you to be able to speak up, raise your concern, address an issue, and still continue to be able to provide more information. However, I think as we know, and as I've discussed before, the classic definition or explanation of whistleblowing, with that identifying themselves and coming forward, that brings a certain weight and like as I said, like trust to it based on like who that person is, their willingness to step outside and say, like, it's me, I'm saying it. And in other cases or other examples we've seen in the past, depending on how high or authoritative that person is, in their internal structure or hierarchy, it also adds a little bit of weight of seriousness to a report. A question I'll pose to you is, what are some practical steps that UAE businesses should take to create more effective, let's say, like, compliant whistleblower regulation or policy, whether that's internal or if you have to follow something externally?
Yeah, I mean, look, I think, the concept of whistleblowing in the UAE is relatively new, but it is now becoming a key issue. So a lot of employers are implementing a whistleblowing procedure within their workforce. I mean, some employers are implementing some form of a hotline where employees can make protected disclosures confidentially, or a whistleblowing policy, or coupled with, I guess, a whistleblowing policy really, that will explain to employees how protected disclosures can be made. For example, there's an email address or a hotline number that can be called, as well as the process once the disclosure has been reported. And I think, obviously we've discussed confidentiality and anonymity, quite a lot in this presentation, but normally a policy would explain in sufficient detail that the details around the person making the protected disclosure would be protected. The disclosure will be treated confidentially. Employees are generally reassured that they will not suffer retribution or retaliation, especially where disclosures are made in good faith. So I think, from an employer's side, it is important to explain, well, what would constitute whistleblowing or its protected disclosure. And often we see employees getting confused between a grievance, which is obviously a personal issue, perhaps bullying in the workplace, versus a protected disclosure, which is some kind of, unethical potential, concerns that they have seen in the business operations. So it's important, I think, in a procedure or a policy to outline what those differences are, to ensure that the disclosures that are being made are protected disclosures within the meaning of a whistleblower and whistleblowing generally in the UAE. And it should then go into what the ability of the individual has in terms of making that disclosure in the first place, how any investigation into the disclosure will be undertaken, what potential other, recourse the individual has, whether that's external, for example, in the ADGM, well, in the DIFC or with the DFSA, what, external help could they seek to get guidance on, should they require it, but then also give them a level of security and comfort to know that if a disclosure is made, they will remain confidential. The disclosure will remain confidential. They will not be subject to retribution or retaliation. The other thing just to mention is defamation in the UAE. It's slightly different to it as elsewhere in the world, where in the UAE, it doesn't matter if the statement that you're making is true or false. But if you say something negative about somebody else publicly or in front of other people, for example, that could amount to defamation, which is a criminal offense. I mean, in other jurisdictions in the world, obviously defamation is where you say something that's false about someone. But in the UAE, it could also be a way of saying something true. So that is something that's quite important for individuals to bear in mind when they're making a disclosure. And that's also why it's so important for companies to maintain confidentiality surrounding protected disclosures, to ensure that employees are aware that if they make these disclosures, they will be protected from potential, direct criminal breaches of laws if they did go down that road.
Yeah, and I think we touched on that earlier,
Yeah.
that there is a little bit of navigating that has to be done there, because although I think we're talking about, in good faith, doing the right thing, you can still do it the wrong way, right?
Yeah, absolutely.
Which is the tricky part. But again, that's why we're having this conversation now, and why we'll both, or at least our companies, be available to give that additional kind of support and try to be, adaptive in those specific needs, whether it's in the UAE or really, anywhere in the world.
Yeah, exactly. And I think, when you start implementing these policies and procedures that we've mentioned, there will, and as you mentioned, Ry, there will need to be some form of a training session on whistleblowing, how it's being adopted internally, making sure that employees feel supported, encouraged, and so on, and that everyone understands what rights they have in terms of that whistleblowing protection.
How do whistleblower protections contribute to corporate governance, and also how do they enhance a company or an organization's competitive edge?
Yeah, I mean, I think that we touched on a lot of it already around, having employees feel safe and secure in a workplace. Obviously, that in themselves forms part of their motivation to continue working for that business, where they see, potentially bad ethics being conducted by certain individuals and nothing's being done about it. Again, this type of ability to raise concerns, but feeling secure in yourself as an individual in the business and knowing that your company is taking those concerns seriously, and where required, adapting its internal policies and procedures, or imposing disciplinary sanctions on those that are in breach, is really quite important for not only, just continuity of business operations, but growth and really pushing your company forward, and to give you that competitive edge, to give you that edge with your market, and to ensure that your employees really are also fully engaged with you as an employer. So, you are seeing now, especially from larger multinational employers, the implementation of an active, proactive implementation of whistleblowing hotlines, whistleblowing policies, the use of independent third parties to investigate, to help support, non-bias or, fairness and transparency within the workplace, to try and limit individuals within the company becoming aware that disclosure has been made, and using external resources where available to them. So I think, it's important for employees to know that their employer is committed to listening to and acting upon concerns raised by its employees. And I think ultimately that in itself, coupled with obviously just general best practices, will give an employer the competitive edge that it needs in order to build its business and grow.
Yeah, absolutely. And just to add on just a little bit, because you've now mentioned a few things that I always try to kind of mention in terms of, there are also like other benefits in terms of, just simply like boosting your brand in terms of, how it's perceived externally, in that regard. But also there are some other like financial benefits that we often highlight, or at least I do in my writing and in a few of the sessions we talked about, in terms of like attracting top talent over to you. If you know you're going into a place that cares, that you're protected, that sends that message that your opinions, concerns, or maybe even other issues would be addressed, and you would be at least not only acknowledged, but there's some sort of framework that allows protection, or you know, there are varying levels of it, as we discussed, based on what the scenario is, but at least that there's something in place that says we do encourage and acknowledge these things, and we want to give you the best chance to do it in the right way that both protects you and protects us. So there's kind of that mutual benefit there. But as a if you're an international company and you're looking to hire international people, no matter where you are in the world, these are some of the kind of benchmark standards that are now becoming just as important as some of the well-being policies that other companies maybe stand behind. And on the topic of top talent and employees as well, these types of issues that go unaddressed, or there's no voice of the employee, does lead to more turnover. And the research that I'm doing about it, that's actually a huge business cost. On the flip side, another thing that we've kind of uncovered is that there are millions of dollars that are lost internally due to fraud or misconduct in these things. So having these types of policies where you can address that, not even against the company, but maybe it's for example, a colleague or someone that's doing something that hurts the company. These are the particular areas that addressing or raising a concern can help save that company money. And, it's again another area that I think goes somehow overlooked, but this type of approach actually helps you in the long term in terms of not only protecting your reputation and integrity, but it helps your bank account in terms of loss otherwise, right? I mean, if there's some kind of internal fraud that goes unnoticed for long enough, that's millions and millions of dollars that otherwise would have helped build your company into greater success. So there are just a few of these things that you might not instantly think about. How is a whistleblower, or how is anonymous reporting going to help me as an organization? Well, there are some examples. It's your reputation, it's your finances, it's how you're perceived in the world with international partners or locally. Their expectations are changing, right? And I think these are some pretty big things to consider. So that was just my last appeal for taking these concepts, maybe to the next level, or at least opening up, the curiosity about them to start those conversations. And especially jumping back when we were talking about the ADGM, there's a deadline coming up around the corner in terms of, if you need to start taking action, there's no better time than now. So on that note, before we jump into the Q&A, Sabrina, I just want to say thank you for, coming along with me on this journey. It's a pretty whirlwind rapid fire questions. There's so much to cover. You gave such great insight, and I really do appreciate you taking the time with us today to at least preview some of these things. And to the audience, I do strongly encourage you, if these particular, let's say, laws or regulations are something that's on your radar already in the UAE and the regions around, I would say please do reach out to Sabrina and her team. They are legal experts. They are right there for you. Sabrina, before we go, do you maybe have like a final thought, or something else that you'd like to just lightly mention?
Now is a really good time to kind of get on top of, protected disclosures in general, whether from a legal perspective or, internally how your business operates, not only to protect the business, as you mentioned, Ry, but also, in compliance with legislation that is evolving, that is developing, that is being brought in the coming months. And, we're looking at this not only from aligning with laws in the UAE, but we're looking at kind of a global push towards, regulatory compliance in general. And I think to ensure that your business stays at the forefront of its industry, these are live considerations that really need to be taken into account at this stage, at this infrastructure. I mean, the UAE is also developing so quickly at the moment that, these are things that ultimately the company really should be staying on top of, should be progressing, and should be developing in line with the way in which legislation in the UAE is also developing. So, that's, I guess, that's what my position would be on it. I mean, I think it's a really important, just general point in terms of legal compliance within the business, regulatory compliance within the business, as well as legal compliance in general across the jurisdiction in which any company operates. And on the flip side, keeping your employees happy, motivated, secure, and trusting the company in which they are employed by.
I think that's also a really important thing. Just to kind of tie this all together, it's not just about understanding the laws or the changing regulations. It's also about how you engage internally about it, that you make it somehow a little bit more visible and welcoming that we are taking these steps, even if there's no action meant to be done by an employee or by a team, just to make it clear that, we are moving in this direction. If you want to know more, reach out to us, because this is what we can share with you. And this is how we want to keep you, if not involved, but at least aware. I think the engagement part is something that's also a little bit overlooked in some cases, which might help greatly, especially when we're, adopting new policy, new regulation, and these types of things.